And so obviously the whole solution here was that the power, the government, would be proportioned amongst everybody, every person. Also, the persons holding office, our representatives, are elected by the people either directly or indirectly. We vote for people to elected office, but also sometimes those people get appointed by people we voted into elected office. So it's either direct or indirect. Offices have tenures. That means nobody gets to stay forever. Now, even the judiciary has a tenure. Guess what it is? For good behavior. That means that when the judges stray, and we'll see this later, the Congress has the authority to remove federal judges from office for straying from good behavior. Now, this whole form of government, these 6 first principles there, are bound together by this document called the Constitution, or Constitutions. Let's look at what the United States Constitution says, since it was the first thing I mentioned on the subject of taking a person's life, murder by abortion. It says in the 5th Amendment, and I want you just to put on your simple thinking hat. The people who wrote the document, and I'm not saying it's a perfect document, clearly abuses happen, but the people who wrote the document wrote these words: no person shall be deprived of life, liberty, or property without due process of law. Seems fairly straightforward, not too much that you would think that you could read into there. I'm going to go to the 14th Amendment now. The 14th Amendment was passed after the Civil War, and you would think, well, why do we need another amendment? That sort of says the same thing, and there were reasons for the 14th Amendment after the Civil War in the southern states. But by the incorporation doctrine, the 14th Amendment is now binding upon all states, the first 10 amendments. But it says specifically, nor shall any state deprive, I have it underlined, any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. There's equal protection under law for every person in the United States of America, theoretically, in the Constitution. Pay real close attention to the wording of that 14th Amendment. We'll come back and revisit that and see what the Supreme Court of the United States said about that particular amendment. Now we have also the Idaho Constitution. So I said we had federal and state constitutions. The Idaho Constitution is actually a pretty good document. Now I'll give you an example of the Second Amendment, which says that it starts with using the word militia. And so with the Second Amendment, people try to claim, well, they meant militia. Well, if you read back in history and understand what a militia is versus a standing army, you'll get a sense of why that means every person has the right to keep and bear arms. But the Idaho Constitution just says every person has a right to keep and bear arms. Now, it also says, starting right off, Section 1, Article 1, all men are by nature free and equal and have certain inalienable rights. We'll talk about what that means in a moment, among which are enjoying and defending life and liberty, acquiring, possessing, protecting property, pursuing happiness, and I like that last underlined part there, securing safety. That means all men have that as an inalienable right to secure safety. So if you also want to talk about the right to keep and bear arms, don't ever forget to bring up Section 1 of Article 1 of the Idaho Constitution. Section 2, Article 1. It's the next section right there. All political power is inherent in the people. We talked about derived a moment ago. It's inherent in the people. Government is instituted for their equal protection and benefit. That's the purpose of government, is to equally protect everybody and benefit everybody. We go down further in the Idaho Constitution to Section 18. Courts of justice shall be open to who? Every person, and a speedy remedy afforded for every injury of person, property, or character, and right and justice shall be administered without sale, without denial, without delay, and without prejudice. In other words, every person, we're not going to take this group of people and deny them justice versus this group over here. We're not going to sell their justice away. We're not going to delay their justice. This is basically equal justice. Equal justice, equal protection, equal rights. Now, what about God's law? And again, remember I said earlier, and I said that we have as a foundation United States Constitution, the Idaho Constitution, God's law. What about separation of church and state that you've heard of, the so-called separation of church and state? Well, separation of church and state all depends on the First Amendment. In other words, where would we find even such a concept that exists? In the First Amendment of the United States Constitution, it says, Congress shall make no law respecting an establishment of religion. So that's, anytime you look at constitutional law, and you've got one little part of the sentence right there, an establishment of religion, that's called the Establishment Clause. And the one right after that, prohibiting the free exercise thereof, is called the Free Exercise Clause. So if you ever see those referred to in an article, that's all they're talking about. That's the entire portion of the First Amendment we're talking about there. What did it mean to talk about the Establishment Clause? Is there really a fact that you can't include God's law or God's will in the law? Well, the first Supreme Court case, apparently our founders were not confused about this because this never came up in the early part of our country until 1947. It came up in a case. It was called Edison versus Board of Education. Okay, and in Edison versus Board of Education, this is a quote from the court. They were examining what is the Establishment Clause and what does it mean for, this is the United States Supreme Court, to say that Congress, and remember by the incorporation doctrine of the 14th Amendment, the states cannot make laws that establish religion. Well, think about our history and where we came from. We threw off the monarchy, where the monarch was the head of an established church, and all participants in the realm had to attend and financially support the established church. So if you look up Edison versus Board of Education, you're going to see they talked about that very thing, that what the Establishment Clause was is, sure enough, by the charters of the first part of our union, it was imposed upon the colonies that these colonies were creating churches. They were forcing people to attend. They were forcing people to support these religious orders. And sometimes these religious orders were very much against what your particular belief might have been. So the court concluded in Everson versus Board of Education, they said that it was basically abhorrent. You notice the last word there. They said that these practices became so commonplace as to shock the freedom-loving colonials into a feeling of abhorrence. We don't want to force you to participate in church, and that's what the Establishment Clause is that the government should not create a religion and then compel everybody to participate. That's all it is. So what it is a prohibition on government creating religion, and what it is not is a prohibition on incorporating God's law into man's laws, or a prohibition on recognizing that there are certain immutable laws. That's why we have criminal laws against homicide, against rape, against theft, etc. These are immutable laws. They're obvious laws. They're things that are unchangeable and that have been with humans since the beginning of history. Since we can recognize that God exists, because it's not prohibited by the Constitution of the United States or the Idaho Constitution, we have in our Idaho Constitution this preamble, which is not binding law, but it says, "We, the people of the state of Idaho, grateful to Almighty God for our freedom to secure its blessings and promote our common welfare, do establish this Constitution." That's the state of Idaho. Then when we say, going back to Article 1, Section 1 of the Idaho Constitution, when we say all men have certain inalienable rights, if they're inalienable and can never be taken away, they must come from someone other than men. Because we obviously alienate people's rights all the time. We did with murder by abortion. What we're talking about here is rights that come from God. That's what inalienable are. So they're unable to be taken away from or given away by the possessor, but I've got news for you. They actually are taken away from the possessor, often by men, but they should not be, and good men and women should rise up against the tyrant and the oppressor that would deprive someone of their inalienable rights. That's what good people do. So since we can talk about God's law, then one law in the Bible, what does it say about murder by abortion? It says, thou shalt not murder, thou shalt not kill, depending on your translation of the scriptures and the fifth commandment. Not allowed to unjustly murder anybody. Whoso sheddeth man's blood, by man shall his blood be shed, for in the image of God made he man. Genesis 9:6. This is the reason that human beings are different from animals. This is the reason we can kill animals and eat them for meat, is because they're not made in the image of God. And this is the sole reason that God says you may not unjustly kill another person, because shedding their blood defiles the land. And it brings blood guiltiness upon the state of Idaho. When we allow 28 children to be murdered in abortions every week in the state of Idaho, we are accumulating the blood guilt of their blood shed, and that is an immutable law. Once we've done that without justice applied, or without seeking justice, we can't change that. But we can repent and stop accumulating the blood guiltiness. Amen. I go to Proverbs 6:17. These things, and lists a bunch of things the Lord hates, but he also hates the hands that shed innocent blood. Who but a preborn child is more innocent than anybody else? Romans 13. Okay, since we're using Scripture as a guide, we have to talk about what is the source of government. God is the governor, the supreme governor, but he is delegated to men authority. So when the state of Idaho and any other state acts in a governmental capacity, they're acting in the stead of God. They are ordained by him for a certain and really limited purpose. God said of government that they are the minister of God, a revenger, to execute wrath upon him that doeth evil. And it also says to commend him who does well, who does good. That's 1 Peter 2 as well. Well, if government's going to properly fulfill its ordination, the first thing it's got to do is properly define good and evil, and punish evil and commend good, and not call good evil and evil good. So now I get into, why is abortion legal, though not lawful, in the state of Idaho? Okay, some people don't know this, but before Roe v. Wade, because you immediately will have a gut reaction and say, hey, it's legal because of Roe v. Wade. It's not legal because of Roe v. Wade. 20 states had legalized abortion before Roe v. Wade. Some, for any reason whatsoever, and very interestingly, in the state of Washington, our neighbor, they actually did it by our beloved voter referendum. By the way, this is where ballot initiatives and referendums are bad if they don't conform to the Constitution as far as what they're actually accomplishing. And that would be then up to the governor and the state legislature to undo such a thing as what happened in Washington when the people of Washington said, we want to allow murder by abortion for any reason up to 12 weeks, was what that particular referendum in 1970. If Roe were vacated, we're going to get into what that would mean, but if Roe were vacated by the Supreme Court and they said, oh, I'm sorry, we made a terrible mistake, and abortion, murder by abortion, is not actually constitutional, then it would still be legal in the state of Idaho today. And it would still be legal in every state in the Union today, even if the Supreme Court said it was not. Why? Because our statutes say that it is legal in the state of Idaho. But I'm going to go with the idea that in 1973, it's widely recognized that for the 30 states that had not said you can get an abortion whenever you want, that Roe v. Wade did precipitate abortion on demand throughout the United States of America. So let's see what they said in Roe and see if what they said makes sense and see if it was lawful. So what was Roe v. Wade? Well, it was a case about the Texas abortion statute. See, back in 1971 or 70, when the instances, the occurrences that led to Roe v. Wade came up, Texas had laws against abortion. They weren't exactly the right laws, but they were against abortion. And so Norma McCorvey, filing as James Roe, actually had an activist attorney use her to file a case challenging Texas's abortion laws at the time. And you'll note that what the Supreme Court said is the principal thrust of the appellant's attack on the Texas statutes is that they improperly invade a right said to be possessed by the pregnant woman to choose to, notice these clinical terms, terminate her pregnancy, otherwise known as paying someone to dismember your small child and throw their body away. Appellant, this is what they were seeking in Roe, would discover this right in the concept of personal liberty embodied in the 14th Amendment's due process clause. Remember, I told you now what due process clauses are and what the clauses mean. Nobody will be deprived of life, liberty, or property without due process in law of the 14th Amendment. So basically, Roe is claiming that in this deprivation of liberty, I'm losing my liberty to kill my child. But we forgot that life is also in that sentence. So this is interesting. So this is what the state is going to, or the Supreme Court is going to take on in Roe v. Wade. Now this statement here, hopefully if you can't read it, I'm going to read you this. This is from the Roe opinion. Our task is to resolve the issue, whether there is a right to kill a child, by constitutional measure. Now if you think about a court, using the Constitution as a measuring stick is exactly what they're supposed to do. That sounds good. Now let's go ahead and go see if they did that. Now, Herndon Blackman, who wrote the opinion, said, because we have required entering in this opinion place some emphasis upon medical and medical legal history and what that history reveals about man's attitudes toward the abortion procedure over the centuries, you're going to find out that's what the entire opinion is. Basically, the Roe v. Wade opinion is what I call raw judicial activism. It's not actually based on law. So he proceeds in the opinion to render many, many pages of opinion on ancient history, not the Constitution of the United States. And I'll give one example. It's the Hippocratic Oath. The Hippocratic Oath is considered to be the gold standard of medicine. It says, I will give no deadly medicine to anyone if asked, nor, this is the full Hippocratic Oath, suggest any such counsel, and in like manner, I will not give to a woman a pessary to produce abortion. Now, the Hippocratic Oath is dated 377 to 460 BC. It's really old. When we think about it, we think about the gold standard for medicine. Blackman recognized that. He had this big issue. If he was going to say that abortion was a lawful right, how do I deal with this Hippocratic Oath? And the reality is Weddington, the attorney for Roe, did not address the Hippocratic Oath and any of her filings. And Roe v. Wade, if you didn't know, actually had oral arguments in 1971, and Blackman insisted to bring the parties back and rehear oral arguments again a year later because he was not satisfied with the oral arguments. And one of the issues he had was with the Hippocratic Oath. Well, he goes into history and he finds a guy named Ludwig Edelstein, who is a doctor from the 1940s, who basically wrote a book and convinced Blackman on the Supreme Court of the United States that the Hippocratic Oath was actually not widely considered to be the accurate medical standard in its time, and it was, believe it or not, have you ever heard of the Pythagorean theorem? Okay, A squared plus B squared equals C squared. The Pythagoreans were the ones who liked the Hippocratic Oath, but they were just a small group, Blackman writes, of practitioners at the time, and Christianity had a little influence on the Hippocratic Oath and its interpretation. And really, it was really all about the woman. The Hippocratic Oath was said, don't give her an abortion because it's dangerous, it might hurt her, and was never about the child. That's what Blackman wrote in these slides that I have up here, and I'm not going to go into detail about all of them. And you can read pages and pages where he writes about the Stoics. Who are the Stoics? And the Pythagoreans and Hippocrates and all kinds of ancient history. And then he talks about culture, stuff that I do want to read And the bottom line is, he says it seems to us, because he somehow really needs to settle this question, he's going to say abortion is legal. It seems to us it is a satisfactory and acceptable explanation of the Hippocratic Oath's apparent rigidity, where it didn't allow any abortion. It enables us to understand in historical context a long accepted and revered statement of medical ethics as not really being important. That's what he said. Honestly, if you read it, it almost reads like fiction. It's just one man's opinion of history. The Constitution, he says in Roe v. Wade, does not define person in so many words. The whole basis in Roe was, let's justify how law and history never treated the preborn child as a person. And I'm going to tell you, all of that's irrelevant if our knowledge now says that the preborn person is a person. It doesn't matter what history says. It doesn't matter if an unenlightened previous generation of humans thought it was okay to kill children. If it's not okay to kill children, that's what the law is. And that's what our law should be. But the Constitution, he said, in nearly all these instances, the use of the word, which we've already looked at in the Constitution, is such that it has application only postnatally, after you're born. None indicates that it has any prenatal application. In other words, preborn. That's what Roe v. Wade said. All this together with our observation that throughout the major portion of the 19th century, that is the 1800s, prevailing legal abortion practices were far freer than they are today. All of that persuades us that the word person, notice what he's doing. He's saying our Constitution says no person's going to be private life, but because when I look back at history, I'm convinced that person doesn't really mean person. Person does not include the preborn. As used in the 14th Amendment, it does not include the unborn. That's what he wrote. That's Roe v. Wade. He said, we need, listen, this is the Supreme Court of the United States. He says, we need not resolve, when we decide that we're going to let women abort their children, we don't need to resolve the difficult question of when life begins. That's in the Roe v. Wade. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer of when life begins. Yet then they certainly make a decision, don't they? They say, we're not in a position to speculate, but it certainly doesn't begin in fertilization. You understand that's what they just said? We therefore conclude that the right of personal privacy includes what he calls the abortion decision. And he says whether it be founded in the 14th Amendment or in the 9th Amendment, he says, he goes on to say, maternity, listen to these words carefully, maternity or additional offspring. This is in the Roe v. Wade. Maternity or additional offspring may force upon the woman a distressful life, and future psychological harm may be imminent. Mental and physical health may be taken or taxed by child care. There's also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable psychologically and otherwise to care for it. In other cases, as in this one, the additional difficulties of and continuing stigma of unwed motherhood may be involved. All these are factors the woman and her responsible physician who's going to perform the abortion necessarily will consider in consultation. Does that sound like the Constitution of the United States being highly respected as a source of law, or God's law being highly respected? It sounds to me like there's social upheaval in the 1960s sexual revolution, and women want to be able to kill their children by abortion, and by judicial fiat, the Supreme Court is going to let them do it for any reason. I'm just going to bring you right back to the 14th Amendment. Nor shall any state deprive any person of life. Remember, go to your K through 12 classes tomorrow in the state of Idaho. Have them read the 14th Amendment, and in that one little word, liberty, there, in that one little word, forgetting the word that's right before it, is the right to kill your preborn child. That's what Roe v. Wade said. Then there have been dozens of cases since then that have affirmed it. I'm going to say that in Planned Parenthood versus Casey, I want you to read this first sentence of Sandra Day O'Connor. And this is how the Supreme Court works. They make a decision and then they double down and triple down and dozens down. The obligation to follow precedent begins with necessity. We recognize that no judicial system could do society's work if it eyed each issue afresh in every case that raised the issue. The very concept of the rule of law underlying our own Constitution requires such continuity over time that a respect for precedent is by definition indispensable. We can't get rid of precedent. That's stare decisis. So once the Supreme Court heads down a particular road, it does not do society any good to change course. And we will use the precedent then as our justification. By the way, precedent, you will find, gets cited in most Supreme Court cases, and rather than looking at the Constitution, they are looking at previous Supreme Court decisions. Now, this is an amazing thing. This is back to the Roe v. Wade opinion. This is black. So every time you seek a lawsuit, you're going to see, I want a declaration from the court that Texas abortion laws are unconstitutional. And then I want the court to issue an order saying, Texas, you cannot enforce your abortion law. Well, guess what? That was not sought and granted by the district court, forcing them to not enforce their law. And so that's called an injunction. And because it wasn't sought, the Supreme Court could not then turn around and order Texas not to enforce their abortion law. Listen to what he said. We find it unnecessary to decide whether the district court erred in withholding injunctive relief because we assume the Texas prosecutorial authorities will give full credence to our decision as if we have ruled and it is the law of the land. And that is exactly the way the Supreme Court of the United States operates, only because we, the people, and we, the states, allow them to do it. That's the only reason. So they said, by judicial fiat, we're going to settle a cultural and social question, and we're going to imprint it across the whole United States of America. Ladies and gentlemen, behold your God. That is exactly the way we function in the United States of America. That court is our God. They settle every social and legal question, no matter what it is. Homosexual marriage, Idaho has to pay for a transgender operation for an inmate in the Department of Corrections. If that ever gets up at the Supreme Court, we will settle these decisions for you. Behold your God. Never mind the rule of law of constitutions or the law of God. This is a drawing from Hans Christian Andersen. It's The Emperor Has No Clothes. So this story is about a vain emperor who cares too much about wearing and displaying clothes, so he hires two weavers who convince him, he's not actually a very smart emperor, that they weave the most beautiful clothes in the land, and nobody else appearing to want to be stupid pretends that the emperor is wearing these gorgeous clothes. The reality of the Supreme Court of the United States of America is like Hans Christian Andersen's The Emperor Has No Clothes. They actually have no clothes because they have no actual power unless we grant them that power or control. So we, the Abortion Human Rights Act, challenge the belief that the United States Supreme Court opinions are law, and we challenge that, and we say the Constitution is law. I'll give you just real quick history, and then I am done. Federalist number 81, a legislature, after a judicial decision, this was written by Alexander Hamilton. This was how the Constitution was thought to supposed to work. This is the guys arguing for the Constitution so that the states would ratify. A legislature, that would be the Congress or state legislatures, after a judicial decision, may prescribe a new rule for future cases. What that's saying is, he said in Federalist number 81 in 1788, Hamilton said that if the Supreme Court makes a decision, or the judiciary, it would be unfair for the Congress to go change the decision or the impact of the case, like Roe v. Wade and Norman LaCour in particular. However, if the Congress does not like the decision of the court, they can change the law for all future cases. That's what they wrote in the Federalist Papers as how our government is supposed to work. I also have to point out there is no federal statute that says abortion is legal. There's none. We're only operating from a judicial opinion, no actual law that was passed by a legislature when that case came up. A legislature also, he said, particular misconstructions and contraventions of the will of the legislature. In other words, when the judiciary violates the will of the legislature, they may happen, that can happen, but they can never affect the order of the political system because the judiciary has comparative weakness and total incapacity to support its usurpations by force. What that means is, when the judiciary, the United States Supreme Court, says that homosexual marriage is lawful, they don't have any power to enforce it. They don't have an army, they don't have police, they don't have prisons and jails. There are literally 9 people in black robes. That's it. They expect the state of Idaho to enforce their opinion as if it is law, or any other state. And the important constitutional check from the same Federalist number 81 is that the judiciary can be recalled. In other words, they can be booted out of office by the Congress of the United States. And that would make them never stray from the Constitution. That's what he's saying here. There can never be danger that the judges, by a series of deliberate usurpations on the authority of the legislature, would ever hazard their job, because they know that their job is in jeopardy if they go astray from the legislative will. Except they've got the Congress believing that they have ultimate authority over the Congress, when it was actually, if you just read the Constitution, all the Congress has to do is say no and boot them out, and all the state of Idaho has to do is say no and boot out any impact of Roe v. Wade. Federalist number 45, the powers delegated to the federal government are few and defined. The federal power will be exercised principally on external objects as war, peace, negotiation, and foreign commerce, and the powers reserved in the several states will extend to the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. And the operations of the federal government will be most extensive in times of war and danger, and those of the state governments in times of peace and security. So the federal government should be very little and minimal impact on our life, because we shouldn't be at war. Oh, I forgot, we're at war since 2001. But the whole idea behind the actual design of our government was that the federal government would hardly do anything except for essentially regulate interstate commerce, regulate foreign commerce, and provide for the national defense. That was it. Now we'll get to a whole lot more on this subject. But the bottom line is that abortion is murder, and it's not lawful, except for the fact that we're living a lie. Yep. The illusion that whatever the Supreme Court says we must bow down and obey them. The state of Idaho has no obligation to do so, and I guarantee you that our founders did not throw off a monarchy to exchange it for an oligarchy. Now, an oligarchy is rulers of a few people. That's not what we exchanged out. Now I'm going to, and Russell, do you need more time to get ready?
They want to do something like this.
Okay, so we're going to do a 5-minute break, and then we will come back and introduce Russell Hunter, our next speaker.